Hello, this is social media attorney Mark Fiedleholtz, and welcome to my podcast entitled What Realtors Must Know About the New Federal Social Media Policy and Training Standards. Prior to attending my online and live social media liability courses, I was surprised to find out that 99% of the realtors were totally unaware of the new federal social media policy and training standards. This knowledge gap is exposing brokers and agents to great risk of making a costly social media mistake that will destroy their real estate career and personal finances. This is why I felt so compelled and I felt it was so urgent to do this podcast. Here is the format of the podcast. I want to share with you the 7 biggest takeaways you must know from the new federal social media policy and training standards. So let's go to work. All right, takeaway number 1. The new federal social media policy and training standards are a byproduct of recent federal court and National Labor Relations Board decisions that classify social media as an inherently dangerous broadcasting platform that can permanently destroy a person's reputation worldwide. In fact, many recent studies, such as the Pew Research Center, have documented that online harassment has intensified dramatically in the past few years, especially with the viral capability of powerful social media networks. So, this is the reason there are new or higher federal standards on writing social media policies and training brokers, agents, and office staff. Let's move now to takeaway number 2. I want to put this takeaway up front because there is so much misinformation on the issue of insurance coverage, especially when it relates to social media. Here's the bottom line, and it's coming from a 33-year nationally recognized digital media attorney. So please listen to me carefully. The modern trend is for courts to rule that social media harm is not only a permanent injury, it is an intentional harm. So, for the courts to rule that social media is not only a permanent injury and that it's intentional harm, you've got a lot going on there. Let me explain. Judges and juries note that the defendant's post or tweet wasn't an accident. The individual who sent the harmful post or tweet purposely weaponized powerful social media networks to humiliate this person in front of a large audience. So he or she should have, or knew rather, or should have known their comments would create a permanent digital footprint. Therefore, many juries award large punitive damages that agents and brokers end up paying out of pocket. You're probably saying, well, how could that be? I mean, I have insurance, errors and omission insurance, and other forms of insurance. Well, here's the bottom line. Most insurance policies do not cover intentionally malicious or willful conduct. So without insurance coverage, both brokers and agents who posted the damaging comments are exposed now to paying out of pocket for, say, defamation, harassment, and other related social media claims. Now, the average social media related lawsuit is well over $500,000. Although social media may seem like a great branding and selling tool, which in fact it is, but it's also, or it could be, a nightmare ready to happen if you don't have social media policies and training that comply with the new federal standards. All right, let's move now to takeaway number 3. Let's dig deeper on what impact the new federal standards have on your ability to use social media to advertise and sell your properties. You must have a social media policy that complies with the new federal drafting standards. Also, you must use precise social media language in your policy, not the vague boilerplate policy language that 99% of model social media policies use. And by the way, a lot of these policies are from reputable associations, policy services, and other organizations. So the need for clear and specific language is especially important in these social media policies when you're speaking to the issue of First Amendment rights using personal social media accounts. If this language is not precise or very specific, courts will rule the policy vague and invalid. And then what happens is that you have absolutely no protection to either defeat the social media claims or at minimum mitigate damages by showing that you are in compliance with the new federal social media policy standards. Let's move on to takeaway number 4. takeaway number 4, I want to go more in depth on the issue of boilerplate social media policies. What makes this topic so complex is, as I mentioned before, unknowingly, many of these policies come from reputable national and state real estate associations and respected policy services. And unfortunately, a lot of these associations and services are cranking out boilerplate social media policies that only cite minimum standards, not the federal standards. Also, the model policies are written by real estate or employment law attorneys, not by a specialist in social media law or digital media law like myself. And what happens is this results in social media policies that are way too overbroad, and the issues that carry complex legal nuances and hidden liabilities are totally overlooked. And it's really a huge problem. And in the end, you're just left unprotected, and the courts are going to rule the social media policy invalid, right? Like I said. So a lot of times, though, you don't even realize it until there's litigation. When the social media is tested in court, then all of a sudden these real estate firms realize that, oh, wow, maybe I shouldn't have placed blind trust on these social media policies just because they came from reputable organizations. And what happens here is it triggers costly legal damages that destroy a realtor's career and personal finances. All right, let's move to takeaway number 5. In addition to having a social media policy that complies with the new federal drafting standards, you must enforce the policy with specialized social media liability training for all agents. I can't be emphatic enough. You're dealing here with a high liability issue that can reach millions, cause permanent reputational damage. You can never get it off. You just can't hand out a piece of paper. You have to have training, and that's U.S. Supreme Court law, by the way. You have to have training to enforce the policy. So what we're talking about here, and when I mentioned specialized training means your social media law instructor is a court-qualified social media attorney who specializes in social media law, not real estate law or employment law. This is the biggest problem I see with most conferences. The instructor is an attorney, but not an attorney that specializes, like I said, in social media law. And what happens here is conference attendees end up leaving, with more questions than answers, or the worst case scenario is they think they're actually trained, and then they don't get any further education. Now, let me use the medical analogy, right? I mean, if you have a heart problem, you consult the advice of a cardiologist who's a heart specialist, not a podiatrist who specializes in foot problems. And today's attorneys are specialists, just like doctors. Now, here's a revealing statistic. Out of the thousands of brokers and agents who took my basic social media law pre-test, the average score was 13%. I mean, it was just mind-blowing to me, right? I mean, these are really smart people. But when it comes to social media law, they're just not getting the in-depth education, the realtors, that they need. In fact, despite telling me, the people who took this test, that they really didn't need my online social media liability course because they attended conferences on social media law or did some online research, not one broker agent could tell me the basic core element of their state libel or libel by implication statutes. Additionally, not one broker agent could differentiate between a First Amendment protected pure opinion and a fact. I mean, these are fundamental legal concepts you got to have, right? So, I mean, you have agents sending posts on social media, and brokers too, sending posts on social media to millions of people worldwide, all right? And it lives on in perpetuity. I mean, you'll never get the comments off. And not one agent or broker is familiar with their state libel laws, new First Amendment rulings, and copyright laws. I mean, that's just a recipe for disaster. All right, let's move on to takeaway number 6. And again, these are the takeaways from the new federal social media and policy training standards that you must know. All right, takeaway number 6. Since social media is such a high-risk area, you must show clients 3 documents when you sign them up. First, you need to give clients a social media policy that is compliant with the new federal standards. And by the way, all these documents, they got to sign off that they received it. So let me take this a little bit further here, right? So you should have the social media policy not only signed by your client, your prospective client, you also want to put it on your website and other digital branding platforms. You want to let the public know that you have a well-written social media policy that complies with the federal standards. Now, the second document, you need to give clients a copy of your social media liability course completion certificate. This certificate acts as proof that both the broker and agents received in-depth social media liability training from a court-qualified social media attorney, not just any attorney. In my online course, participants can print out the certificate once they are done with the course. It's really an important element of my course. You can also use the certificate as a marketing tool to differentiate yourself from the competition. Display the certificate prominently on your website and other marketing materials. So far, we're talking about a well-written social media policy you're going to give to your clients, and you're going to have them sign off that they received it. You can also put that on the website or any other digital marketing materials. You'll do the same with your course completion certificate. I mean, the public and your clients need to know that you didn't just take some generic course, that you took an in-depth course taught by a certified or a licensed social media attorney. Now, the third document, you should give your client a social media disclaimer that, once again, they're going to sign off on. This disclaimer notifies the client that you adhere to all federal and state laws regarding social media speech when you're selling properties with social media. And also, I got to tell you, when I write this policy for a realtor, I am very specific about what the realtor can do and what he or she can. All right. I mean, I don't play around with this stuff. Also, when the client signs the social media disclaimer, they are also attesting to the fact that they will abide by the laws as well. These are three really important documents. All right, let's move on now to takeaway number 7. All right, so number 7, you are risking your entire real estate business if you wait for a lawsuit to comply with the new social media policy and training standards. In addition to defamation, retaliation, negligent training, copyright infringement, and other social media related claims, you also have the other issue of the Federal Trade Commission Act, Section 5, unfair or deceptive acts or practices. Let me explain. You can't claim by omission that you left the impression that you're a guru at using social media. Let me recap that. All right. Let me say that a little bit clearer. Sorry about that. You can't directly or by omission leave the impression that you are a guru at using social media to sell properties, but you're not trained on the core legal issues of social media liability. I mean, you just can't do that. And the way that the client is going to go down on this, if you make a mistake, they're going after you. And you can bet that a plaintiff attorney will be scrutinizing your policy, your disclaimer, whether you had a certificate or not, all this stuff, right? And then they're going to be looking at your advertising as well. And to see if it's incongruous that on the one hand, you're saying what a guru you are, either directly or indirectly, and you know nothing about core social media liability. That's going to be a big problem for you. All right. So, and let me give you another reason besides the FTC that you're going to have to deal with. All right. Another big reason you want to update your social media policies and employee training to comply with the national or the new federal standards is the adoption of the National Association of Realtors Standard of Practice 10.5. And this has had a lot of media coverage, NAR 10.5. With this new standard, the Code of Ethics, it's just essential. All right. Because what's happening here under NAR 5 is it states that realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, handicap, or familial status, national origin, sexual orientation, or gender identity. Realtors must not use harassing speech, hate speech, all right, all the things that I just mentioned, right? But here's the key to this, and where the controversy has started on NAR 10.5, is that this standard of practice is so tricky because it applies to all realtor activities, not just within the confines of a real estate transaction. So it's much broader, right? Now, although interpretations of NAR 10.5 are still being hashed out, it enhances the risk of having brokers and agents inadequately trained on core social media liability issues. So you got 3 things going on here. Not only the reason that you want to know about the federal laws, right? About making sure your policy and training standards are up to snuff on the federal standards because you need to comply. But then you've got false advertising, right? And by the way, that can be state false advertising laws too, and federal. And then you got NAR 10.5. It's just not practical or prudent for you to not do this type of in-depth social media liability training and making sure that your policies are written by a specialist like myself with precision. All right. Well, we've arrived at the end of the podcast. I appreciate the fact that you were able to take time out of your busy schedule to listen to this podcast. If you're interested in my social media compliance programs, such as my online course and customized policy writing service, you can call me or email me using the contact information on the advertisement you received for this podcast. And then also my websites are listed on that as well. All right. So thank you very much for your time. And this is the end of the podcast.